The marble walls of the Supreme Court chamber amplified the tension as Karoline Leavitt, the 25-year-old White House press secretary, approached the podium. Her navy suit contrasted sharply against the rich mahogany furnishings as she faced the 9 justices of the highest court in the land. Justice Amy Coney Barrett sat directly across from her, expression impassive yet attentive, her black robe a symbol of judicial authority. This unprecedented moment, a White House press secretary personally appearing before the Supreme Court, had drawn a capacity crowd. Legal analysts, political observers, and media representatives filled every available seat, all straining to understand why the administration had sent its youngest spokesperson to address the court on a critical First Amendment case. Rather than the Solicitor General Justice Barrett Leavitt began her voice steady, despite the gravity of the moment. Before addressing the constitutional questions before the court today, I must disclose information directly relevant to these proceedings. Information that connects us in ways this court and the American people deserve to know. Barrett's eyebrows raised slightly, the only break in her judicial composure. Chief Justice Roberts leaned forward, visibly concerned about this departure from standard protocol. The other justices exchanged glances as the gallery fell into complete silence. In that moment, no one could have anticipated the revelation Leavitt was about to deliver, one that would not only transform the case before the court, but potentially reshape the relationship between the judicial and executive branches for generations to come. Before diving deeper into this extraordinary confrontation, comment where you're watching from, and don't forget to subscribe so you won't miss our latest political stories. This dramatic face-off between the youngest White House press secretary and a Supreme Court justice is about to take a turn that no one saw coming. Karoline Leavitt had risen meteorically through Republican politics, starting as a presidential assistant press secretary at just 23, before becoming the youngest White House press secretary in American history. 2 years later, her rapid ascent had made her both a conservative icon and a frequent target of criticism regarding her experience and qualifications. Known for her poised handling of the press corps and unflinching defense of administration policies, Leavitt had earned respect even from political opponents for her preparation and composure under pressure. Yet nothing in her career had prepared her for this moment, directly addressing the Supreme Court in a case involving government transparency and press access to classified information. Justice Amy Coney Barrett, at 53, represented a different type of trailblazer. Appointed to the Supreme Court in 2020, the former Notre Dame law professor had solidified her reputation as a meticulous jurist with a distinct interpretive philosophy. Barrett's approach to constitutional questions frequently surprised observers who attempted to predict her rulings based solely on ideological assumptions. The case before the court, Jenkins versus Department of Justice, centered on whether journalists could be prosecuted for publishing classified information if that information revealed potential government wrongdoing. The administration had taken an unexpectedly strong position, defending press freedoms, leading to speculation about political motivations behind this stance. The stakes extended far beyond the immediate case. A ruling could potentially reshape the boundaries between national security interests and First Amendment protections, affecting how administrations, for decades to come, would handle sensitive information and press relations. For Leavitt personally, this appearance carried enormous professional risk. White House press secretaries rarely addressed the Supreme Court directly. Her presence suggested the administration considered this case important enough to break with protocol, but any misstep could damage both her reputation and the administration's position. For Barrett, the stakes were equally significant. As one of the court's newer members, her approach to First Amendment questions remained closely watched by legal scholars attempting to define her judicial philosophy. Her questioning during oral arguments had suggested concerns about both government overreach and legitimate national security interests. The tension in the courtroom intensified as legal teams from both sides watched this unexpected confrontation unfold. Attorney General Raymond Wilson, who had expected to represent the administration's position, appeared particularly concerned by this last-minute substitution, and Leavitt's unorthodox opening, Chief Justice Roberts, known for maintaining strict procedural standards, seemed prepared to intervene when Leavitt continued. "My appearance today represents the administration's recognition of this case's extraordinary significance," she said. However, I must first address information that directly impacts Justice Barrett's potential involvement in these proceedings. The A statement sent murmurs through the gallery. Was the administration attempting to force a recusal? Such a move would be almost unprecedented and potentially damaging to court executive relations. Barrett's expression remained composed, but her gaze intensified as Leavitt organized her papers at the podium. The other justices leaned forward, clearly concerned about this apparent challenge to their colleagues' judicial role. The moment hung suspended between institutional crisis and whatever revelation Leavitt was prepared to deliver. Whatever came next would either represent a dangerous breach of court norms or something so significant that it justified this extraordinary approach. Justice Barrett Leavitt continued, her voice measured but clear. While reviewing documents relevant to this case, the White House discovered information unknown to this court and the American people, information with direct bearing on the constitutional questions before you. Today, Chief Justice Roberts activated his microphone. Ms. Leavitt, if you have concerns about a justice's participation, there are appropriate channels. Mr. Chief Justice, Leavitt interjected respectfully but firmly, this isn't about recusal, it's about historical context directly relevant to the First Amendment questions before the court. Roberts hesitated, then nodded for her to continue. Though his expression remained concerned, light directed her attention back to Justice Barrett. In preparing for this case, our team reviewed previously classified documents from the Pentagon Papers era, documents only recently declassified. These records reveal that, in 1971, during the Supreme Court's consideration of New York Times versus United States, your grandfather James Barrett played a previously undisclosed role that directly parallels the issues before this court today. The high revelation sent visible shock through the chamber. Barrett's expression registered genuine surprise. Whatever Leavitt was revealing was clearly unknown to the justice herself. James Barrett, then serving as special counsel to the Department of Defense, authored a confidential memo arguing against the government's position in the Pentagon Papers case. Leavitt continued, he advised that the First Amendment protected publication of classified information when that information revealed potential government wrongdoing, precisely the question. Before this court today, legal analysts in the gallery began whispering urgently, Barrett's grandfather had never been publicly associated with the Pentagon Papers case, one of the most significant First Amendment decisions in American history. His memo, which we have provided to the court clerk this morning, argued that democratic governance requires informed citizens, and informed citizens sometimes require information the government would prefer to withhold. He further stated that when classification systems shield wrongdoing, rather than legitimate national security interests, the press must remain free to inform the public without fear of prosecution. Justice Barrett leaned forward, her judicial composure momentarily giving way to personal interest. Miss Leavitt, I was unaware of my grandfather's involvement in this matter. How did the White House discover this connection during our preparation for this case? The President ordered a comprehensive review of historical First Amendment cases involving classified information. Leavitt explained, your grandfather's memo was discovered in recently declassified Defense Department archives. The document contains arguments so directly relevant to the questions before this court that the administration felt disclosure was necessary, not to influence your participation, but to ensure the court has complete historical context. The gallery remained silent, processing the implications. Rather than attempting to force Barrett's recusal, the administration appeared to be providing information that might actually reinforce her participation from a perspective sympathetic to press freedoms. Justice Sotomayor activated her microphone. Ms. Leavitt, while this historical context is interesting, how does it specifically relate to the legal questions before us today? Justice Sotomayor, the relevance is threefold, Leavitt responded without hesitation. First, James Barrett's memo provides contemporary understanding of how officials directly involved in national security viewed the balance between classification and press freedom at a watershed moment in First Amendment jurisprudence. She turned a page in her notes. Second, the memo specifically addresses the question of intent, arguing that journalists publishing classified information to inform public debate about potential wrongdoing should be protected, while those publishing solely to damage national security interests might not be. This intent standard is central to the case before you today. And third, Leavitt continued, The memo reveals that within the government itself, there has historically been recognition that classification systems can be misused to shield wrongdoing, providing important context for evaluating the government's interests in this case. Barrett studied Leavitt with measured interest. This information appears relevant, though its sudden introduction is unorthodox. Have you provided copies of this memo to all parties? Yes, Your Honor. Leavitt confirmed copies were provided to opposing counsel and the court clerk. Before today's proceedings, the full memo has been included in the supplemental materials submitted this morning. The confrontation had evolved into something unexpected, not an attempt to undermine Barrett's participation, but to provide historical context potentially supportive of press freedoms, context with personal connection to the justice's family history. Chief Justice Roberts, though still visibly concerned about the procedural irregularity, addressed Leavitt. While the court appreciates historical context, Ms. Leavitt, I must ask why the White House press secretary is presenting this information rather than the Solicitor General or Attorney General. Leavitt nodded, acknowledging the legitimacy of the question. Mr. Chief Justice, the President believed that since this case fundamentally concerns the relationship between government communications and press freedoms, the White House press office has particular institutional perspective. As the administration's primary interface with the press, we daily navigate the tensions between transparency and discretion central to this case. The explanation, while unusual, carried a certain logical consistency. The press secretary regularly made determinations about what information could be shared with the public and what must remain confidential. Exactly the balancing at issue in the case. The gallery remained transfixed as this unprecedented scenario continued to unfold. What had initially appeared to be a confrontation was revealing itself as something more complex in an attempt to provide historical context with unexpected personal relevance to a sitting justice. Justice Kavanaugh leaned toward his microphone. Ms. Leavitt, does the administration believe James Barrett's position should influence our interpretation of the First Amendment questions before us today? Justice Kavanaugh, the administration believes historical understanding of constitutional principles always merits consideration. Leavitt replied, James Barrett's memo doesn't determine the outcome, but it provides valuable insight into how officials charged with protecting national security have themselves recognized limits on classification powers when those powers might shield wrongdoing from public accountability. As the exchange continued, legal observers in the gallery recognized they were witnessing something extraordinary, not merely in procedural terms, but in the substance of the historical revelation being presented and its potential implications for one of the most significant First Amendment cases in decades. With the court's permission, Leavitt said, reaching into her portfolio, I would like to read directly from James Barrett's conclusion, as it speaks with remarkable clarity to the issues before the court today, Chief Justice. Roberts glanced at his colleagues, then nodded his approval, though his expression suggested continuing reservations about this departure from standard procedure. Leavitt extracted a document bearing Defense Department letter, head dated June 19, 1971, just days before the Supreme Court's landmark Pentagon Papers decision. The gallery fell into complete silence as she began reading. While the government maintains legitimate interest in protecting truly sensitive national security information, classification systems lose constitutional legitimacy when they primarily shield officials from accountability rather than protecting genuine security interests. When journalists publish classified information to inform public debate about potential government wrongdoing, the First Amendment must afford substantial protection. Democracy cannot function when secrecy becomes a tool to conceal the very information citizens need most to evaluate their government's actions. Justice Barrett's expression reflected genuine engagement with her grandfather's words she had apparently never heard before this moment. The personal connection was evident, though her judicial training kept her response measured and professional. Leavitt continued reading. As the department's counsel, I must advise that pursuing criminal charges against journalists for publishing classified information that reveals potential wrongdoing would likely fail constitutional scrutiny and damage public confidence in classification systems. The better approach is reforming those systems to ensure they protect legitimate security interests without becoming shields against accountability. She lowered the document and addressed Barrett directly. Justice Barrett, your grandfather concluded by recommending against prosecuting The New York Times, even while acknowledging the genuine sensitivity of some materials in the Pentagon Papers. His position didn't prevail within the Nixon administration, but history has largely vindicated his constitutional judgment. The revelation had transformed the atmosphere in the courtroom. What had begun as an apparent confrontation had evolved into something more profound. The unearthing of historical context that connected a current justice to a watershed First Amendment case through previously unknown family history. Justice Barrett activated her microphone. Miss Leavitt, I appreciate the historical context you've provided. I had no knowledge of my grandfather's involvement in these matters. He passed away when I was quite young, and these aspects of his government service were never discussed in family circles. She paused, choosing her words carefully. While personal connections cannot and should not determine judicial outcomes, historical understanding of constitutional principles certainly informs our analysis. I would be interested in reviewing the complete memo as part of the historical record relevant to this case. Leavitt nodded respectfully. The complete document has been provided to the court, Your Honor. The administration believes it represents important historical context. Regardless of its personal connection to any particular justice, the moment was remarkable for what it wasn't as much as what it was. Rather than attempting to force a recusal or create controversy, the administration had provided historical context with personal relevance that actually seemed to reinforce Barrett's participation from a perspective potentially sympathetic to press freedoms. Justice Alo leaned toward his microphone. Miss Leavitt, while this historical document is certainly interesting, the legal landscape has changed substantially since 1971. How does the administration believe James Barrett's analysis applies to modern classification systems and digital journalism justice? Alo, the administration believes the core constitutional principles remain consistent even as technologies evolve. Leavitt responded, James Barrett identified the central tension between legitimate security interests and the public's need for information about potential wrongdoing. The tension persists regardless of whether information is published in print newspapers or digital platforms. She turned to a different page in her notes. The administration's position is that when classification primarily shields accountability rather than protecting genuine security interests, the First Amendment must afford substantial protection to publication. The medium of publication may change, but this fundamental constitutional principle remains constant. As Leavitt continued addressing the court's questions with remarkable precision and preparation, legal observers recognized they were witnessing a historic moment in Supreme Court advocacy, one where personal history, constitutional principles, and current controversy converged in unexpected ways. Justice Barrett now fully engaged with the substantive issues rather than the unusual procedure posed a question that went to the heart of the case. Ms. Leavitt, the central tension in this case involves balancing national security interests against press freedoms. Where precisely does the administration believe that lines should be drawn, Justice? Barrett, the administration believes the line must be drawn based on purpose and effect, rather than mere classification status. Leavitt replied, when journalists publish classified information with the primary purpose of informing public debate about potential government wrongdoing, and when that publication does not demonstrably harm specific security operations or personnel, the First Amendment should provide robust protection. She continued, your grandfather articulated this standard with remarkable clarity 50 years ago. The administration believes his analysis remains constitutionally sound today. Classification cannot constitutionally shield officials from accountability for potential wrongdoing, even as it legitimately protects genuine security interests. The gallery remained transfixed as this substantive dialogue continued. What had begun as apparent confrontation had evolved into something far more significant, a meaningful exploration of constitutional principles informed by previously unknown historical context with unexpected personal connection. As the scheduled time for arguments neared its conclusion, Chief Justice Roberts addressed Leavitt. Ms. Leavitt, does the administration wish to present additional arguments regarding the specific legal questions before the court today? Mr. Chief Justice, the administration's position is detailed in our briefs. Leavitt responded, I was sent specifically to ensure the court had access to this newly discovered historical context. I'm prepared to address further questions, if the court has them, but otherwise would refer to our written submissions on the specific legal arguments. Roberts nodded, then addressed the courtroom. This has been an unusual proceeding in procedural terms, but the court appreciates historical context relevant to the constitutional questions before us. We will take these matters under advisement, including the previously unknown historical document that has been presented today. As Leavitt gathered her materials to step away from the podium, Justice Barrett activated her microphone one final time. Miss Leavitt, I would like to express my personal appreciation for bringing this historical document to light. While it will not determine my judicial analysis, understanding my grandfather's perspective on these critical First Amendment questions represents significant personal and historical context. The statement, measured but genuine, reflected the unexpected nature of what had transpired, a moment of authentic personal connection within the formal confines of Supreme Court procedure. As Leavitt nodded respectfully and returned to her seat, the gallery remained silent, processing the extraordinary scene they had just witnessed. What had appeared initially as confrontation had revealed itself as something far more complex and potentially consequential for First Amendment jurisprudence. News of the extraordinary Supreme Court session spread rapidly across Washington and the nation. Within hours, legal analysts, political commentators, and media organizations were exploring the implications of James Barrett's previously unknown role in the Pentagon Papers controversy and its potential impact on the current case. Outside the Supreme Court building, reporters surrounded Leavitt as she emerged. The administration believed the court deserved complete historical context for this critical First Amendment case. She stated James Barrett's analysis from 1971 provides valuable perspective on the proper balance between classification powers and press freedoms in a democratic society. When asked about the unusual decision to have the press secretary rather than Department of Justice attorneys present this information, Leavitt explained this case directly concerns the relationship between government communications and the FA press, the very intersection where the press office operates daily. The president believed our institutional perspective was particularly relevant. Legal experts appeared on news programs throughout the afternoon, analyzing the potential impact of this revelation on the case and broader First Amendment jurisprudence. What makes this extraordinary isn't just the procedural anomaly of a press secretary addressing the Supreme Court, explained constitutional scholar Lawrence Tribe on CNN. It's that the administration uncovered historical context, personally connecting a sitting justice to a watershed First Amendment precedent in a way that potentially strengthens press protections rather than undermining them. On Fox News, former federal judge Andrew Napolitano offered similar analysis. The administration took a significant risk with this unorthodox approach, but the substance of what they revealed, James Barrett's remarkably prescient analysis of classification limits under the First Amendment, may prove more consequential than the procedural irregularity. At the White House, President Thompson addressed the situation during a previously scheduled press conference. When we discovered James Barrett's memo during our preparation for this case, we recognized its historical significance and its direct relevance to the constitutional questions before the court. Ensuring this context was available seemed more important than adhering to procedural norms that weren't designed for such unusual circumstances. Legal blogs and academic commentators began analyzing the memo's substance as copies circulated among constitutional scholars. The document revealed sophisticated understanding of the tension between national security interests and press freedoms that many found remarkably applicable to current controversies. James Barrett's analysis anticipates many of the key questions in contemporary debates about classification leaks and press publication, wrote Yale law professor Jack Balkin. His recognition that classification systems lose legitimacy when used primarily to shield wrongdoing rather than protect genuine security interests remains central to modern First Amendment analysis. Former Solicitor General Ted Olson, appearing on NBC News, noted the potential impact on Justice Barrett's jurisprudence. While no justice should be influenced by personal connections, understanding that her grandfather articulated a sophisticated defense of press freedoms in national security contexts provides important historical grounding that may inform her analysis of these complex constitutional questions. Historical researchers began investigating James Barrett's broader career, discovering additional evidence of his nuanced approach to constitutional questions involving national security. Several former Defense Department officials who had worked with him came forward to confirm his reputation for principled analysis that balanced security concerns with constitutional values. The immediate political impact proved complex and unpredictable. Conservative commentators who might typically have criticized the administration found themselves discussing the substantive merit of James Barrett's analysis. Progressive voices that might have been skeptical of Barrett now expressed interest in how this family history might influence her jurisprudence. Justice Barrett herself maintained appropriate judicial silence on the pending case, but issued a brief statement through the court's Public Information Office. "I appreciate learning about this aspect of my grandfather's public service. While personal connections cannot determine judicial outcomes, historical understanding of constitutional principles always merits careful consideration." Legal observers noted that the revelation created an interesting dynamic for Barrett's participation in the case. Having discovered her grandfather had articulated strong protection for press publication of classified information, revealing potential wrongdoing, recusal seemed unnecessary, while her continued participation carried unique historical dimension. Justice Barrett now has the opportunity to engage with constitutional analysis that connects to her own family history in previously unknown ways, noted Supreme Court historian Linda Greenhouse. This doesn't dictate her conclusion, but it provides meaningful historical context for her consideration of these First Amendment questions. Within days, law schools began incorporating the newly discovered memo into First Amendment curricula, recognizing its historical significance independent of the current controversy. Constitutional law professors noted the document's remarkably preempt analysis of classification systems and their potential misuse to shield wrongdoing from public accountability. Media organizations filed numerous FOIA requests seeking additional historical documents from the Pentagon Papers era that might contain further context for James Barrett's position and its reception within the Nixon administration. Several former government officials who had opposed publication came forward to acknowledge that Barrett's concerns about overclassification had proven justified by subsequent historical revelations. The impact on the pending case remained uncertain as the justices deliberated. Legal analysts speculated about various potential outcomes, with many suggesting the historical context might influence the court towards stronger First Amendment protections for journalists publishing classified information that revealed potential government wrongdoing. 6 weeks later, the Supreme Court issued its ruling in Jenkins versus Department of Justice. In a 7-2 decision, the court established stronger First Amendment protections for journalists publishing classified information that revealed potential government wrongdoing while maintaining restrictions on publication that demonstrably harm specific security operations or personnel. Justice Barrett wrote a concurring opinion that legal scholars immediately recognized as significant for First Amendment jurisprudence. Without directly referencing her personal connection to the historical context, she articulated a sophisticated analysis of the constitutional limits on classification powers when used primarily to shield accountability rather than protect legitimate security interests. When classification systems primarily prevent public knowledge of potential wrongdoing rather than protecting genuine national security interests, the First Amendment must afford substantial protection to publication. Barrett wrote, "Democratic governance requires informed citizens, and informed citizens sometimes require information the government would prefer to withhold." The language echoed her grandfather's memo while developing the constitutional analysis in ways relevant to contemporary challenges. Legal commentators across the ideological spectrum recognized the opinion's significance for First Amendment doctrine, regardless of its unusual backstory. For Karoline Leavitt, the experience represented a defining moment in her tenure as press secretary. Her unorthodox Supreme Court appearance had initially generated criticism about procedural irregularity, but eventually earned respect for its substantive contribution to an important constitutional case. In a subsequent interview with Time magazine, Leavitt reflected on the experience. The administration believed the court deserved complete historical context for this critical First Amendment question. Ensuring that context was available seemed more important than procedural conventions, particularly when the information had such direct relevance to the constitutional questions before the court. When asked about addressing Justice Barrett directly regarding her grandfather's previously unknown role, Leavitt explained, "We weren't seeking recusal or attempting to create controversy. We were providing historical context with unexpected personal connection that we believed strengthened understanding of the constitutional principles at stake." The story of Karoline Leavitt confronting Justice Amy Coney Barrett and the stunning revelation that transformed their interaction ultimately transcended immediate political narratives. It demonstrated how history, personal connection, and constitutional principles could converge in unexpected ways that deepened understanding across institutional and ideological boundaries. The case entered constitutional law textbooks not only for its substantive First Amendment holding, but for the extraordinary circumstances surrounding its argument. Future law students would study both the doctrinal significance of the ruling and the remarkable historical revelation that had connected a sitting justice to a watershed constitutional controversy through previously unknown family history. You found this breakdown of Karoline Leavitt's extraordinary Supreme Court confrontation with Justice Barrett informative. Don't forget to like and subscribe for more in-depth coverage of major political and legal developments. Share your thoughts in the comments below about whether personal connections to constitutional history should influence judicial analysis. We'll be following developments and bringing you exclusive analysis as this landmark First Amendment ruling continues to shape the relationship between government secrecy and press freedom in our democracy.